Hello friends, in the series on income tax cases, today we will discuss a very important issue on section 264 revision proceedings. As all we know that in section 264 the assessee has a right to file the revision application before the principal commissioner of income tax where some order is there which is prejudicial to the interest of the assessee. The issue before Honorable Bombay High Court through a writ petition was that if the assessee files a return of income and if he negligently fails to claim section 54F exemption in the return filed by him and even the time for revision of that return is passed, so whether the assessee can claim section 54F exemption by filing the revision petition under section 264. This issue has been decided by Honorable Bombay High Court in the case of Nisarg Ajay Kumar Vakaria versus Principal Commissioner of Income Tax and others, and this case is reported in 488 ITR at page number 75 and the date of the judgment is 3rd February 2026. The present case is very interesting. In the present case, the assessment year involved was 22-23 and the assessee has filed a return of income at a very good figure of 18.10 crore. After filing the return of income, the return of the assessee was processed under section 143 subsection 1 because nowadays the return is processed very early and very fast. But the time for filing the revised return has elapsed. After that, the assessee realized that the assessee could have claimed section 54F exemption, which he could not do at filing the return of income. The assessee has now two options. The assessee can file the appeal before the CIT appeal against the order under section 143 subsection 1 or file the revision application under section 264. If the assessee chooses to file the appeal before the CIT appeal, there can be a very technical issue that there is no tax demand in the intimation under section 143 subsection 1. So why the assessee is filing the appeal before CIT appeal? So the assessee CIT appeal can be rejected on this ground itself. So in the present case, the assessee filed the revision application before the Principal Commissioner of Income Tax that I forgot to claim section 54F exemption in the original return and even the time for filing the revised return has elapsed. So please process my revision application and allow me the well-desired section 54F exemption. But the Principal Commissioner of Income Tax on a very technical ground rejected the revision application of the assessee by relying on the Honorable Supreme Court judgment in the case of Gatse India Limited versus Commissioner of Income Tax, which is a 2006 judgment and which is reported in 284 ITR at page number 323. And the logic given by the Principal Commissioner of Income Tax was that since the assessee has not claimed section 54F exemption in the original return or the revised return, so the assessee now cannot claim section 54F exemption through section 263 revision petition. When the revision petition of the assessee was rejected, the assessee do not have any other option because an appeal cannot be filed before the tribunal against the rejection of the revision application under section 264. So the assessee filed the writ petition in the Honorable Bombay High Court, and when the court heard the matter, the court was of the very prima facie view that in the present case the Principal Commissioner of Income Tax ought to have considered the revision application even though mistake or errors were committed by the assessee in itself in the return of income. The court remanded the matter back to the Principal Commissioner of Income Tax and with the direction that the PCIT should allow the claim of the assessee as per law, meaning thereby that if the claim of the assessee exists as per the law, then that claim should be allowed as per the law. Friends, this case is very important because it has become a very general practice as far as the administrative authorities are concerned. They are just trying to keep the cap on the head of the superior authorities. Whenever there is a need to take some decision, like in the present case, the PCIT should have considered the application of the assessee, but they have given very technical reason that it cannot be, it can be done only through the a revised return or by filing the return of income. So by ignoring the Article 265 of the Constitution of India or Section 4 and 5 that only the real income should be taxed, not the income which has not accrued to the income, and only the legitimate taxes should be collected from the assessee. So all these principles are not considered by the department. So in the present case, much relief was given by the Honorable Bombay High Court by remanding the matter back to the PCIT to consider the revision application of the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Nisrag Ajay Kumar Vakharia versus Principal Commissioner of Income Tax and others, and this case is reported in 488 ITR at page number 75, and the date of the judgment is 3rd February 2026. Thank you, friends.